The Constitution divides power among three branches of government. Congress passes the laws, the courts ensure the laws are constitutional, and the president is charged with enforcing the laws. How the president enforces laws can lead to conflict between the executive branch and the Congress. One bill passed in 2005 set off a fundamental constitutional disagreement between the two branches. Senator John McCain and others in the Senate added provisions to a Defense Department funding bill outlawing the abuse of prisoners. The amendment was a response to charges of torture of detainees held by the Army. It was opposed by the White House and some members of Congress.
It is wrong to presume that there is no place in this country, or in the operation of this country, where we should not have the ability to deal with terrorists on their own ground.
Despite these objections, the bill was approved by Congress. President Bush signed the measure into law, but then issued a signing statement saying he would only enforce those parts of the law he thought were constitutional. He was following a legal theory called selective non-enforcement. It reserves for the president the right to decide whether part of a law is constitutional and if it should be enforced. However, critics charge that the Constitution only gives the president all or nothing power. If the president doesn't like provisions in a bill, he can either veto it and send it back to Congress, or he can sign it. He then must enforce all provisions of the law. Joining us now to discuss selective non-enforcement are two experts. Former Congressman Mickey Edwards represented Oklahoma in the House of Representatives for 16 years, where he served in the leadership of the Republican Party in Congress. He now teaches at Princeton University and was a member of an American Bar Association committee that issued a report about signing statements. Todd Gaziano is the director of the Center for Legal and Judicial Studies at the Heritage Foundation. Before he joined the Heritage Foundation, he worked in all three branches of the federal government, including the U.S. Justice Department's Office of Legal Counsel. The office advises the president on constitutional issues and helps draft presidential signing statements. Welcome to you both.
Thank you.
Thank you.
Mr. Gaziano, since you actually helped to draft these signing statements, when you did that, did you have in mind whether the president and when the president could enforce them?
We received some instruction on what the president needed in the signing statements, but sometimes it was quite clear that there was a constitutional problem with a small portion of the bill. If Congress wants to tell the courts or the president that it shall strike down the entire law if any one little part of it is unconstitutional, Congress can do so. But when Congress is silent, both the courts and the president are doing a service to Congress by enforcing those portions of the statute that are constitutional.
But it's the courts that decide whether or not it's unconstitutional. Under the Constitution, Article 1, Section 7, when the Congress enacts legislation, sends it to the president has only two choices, only two. You know, he can veto it and send it back to Congress, and he can try to pass it again over his veto, or, you know, he can sign it and then it becomes law. And when it's law, it's binding. The president doesn't have the authority under the Constitution to decide to take some of it and not take the rest of it.
Is that what signing statements do?
Well, the president has been declaring that he has the authority as president, as commander-in-chief, and as the head of the executive branch. He has the authority to interpret for himself whether or not he's going to follow provisions of the law.
Do you think that that's the responsibility of the president to do that?
It's the obligation of the president. The president takes an oath to defend and support the Constitution, as do the courts. And when the court is faced with one section of a 600-page law that might be unconstitutional, it is the court's obligation to rule on the constitutionality of it. Well, the president's in the exact same situation. He can veto the whole thing, of course.
And why not then?
But Mr. Edwards is wrong that that's his only option. If it's an emergency supplemental bill for hurricane victims, it includes a lot of other very important provisions, and there's just one section that might be unconstitutional in some circumstances. Then the president can sign the bill and he just instructs the government to avoid acting in an unconstitutional manner.
What's wrong with what Todd just said is the president absolutely does have an obligation not to enforce an unconstitutional law. If he believes it's unconstitutional, he has an oath of office not to sign the bill. Because once he signs it, it's law. And if he believes it's unconstitutional, he shouldn't sign it. I was there many times when a president said, I don't like this provision. I think it's unconstitutional, or I don't like it for any other reason. You know, he can get hold of the Congress. He can say, if this bill comes to me in this form, I will veto it, at which point the Congress and the president sit down together. They can do this very quickly. I've seen them move in a day. You know, they can get together and they can take that provision out, or they can negotiate out the difference. But the Constitution is very, very clear. Article 1, Section 7 says the president can do one of two things. He can sign it. It's the law. It's binding on him, just like it would be binding on either of us or on you. Or, you know, he can veto it, and it's almost impossible to override a presidential veto, almost impossible to do.
Let's talk about a specific case. The McCain anti-torture amendment, as it's come to be known, was something the president wrote one of these signing statements for. He didn't agree that the power he believes that he needs as a president in a time of war should be taken from him by a blank statement made by Congress. Explain to me exactly what the reasoning is behind the decision to do something like that.
Well, that's a good example because it illustrates a kind of a misapprehension of what most of these signing statements say. They generally don't say that the president will never follow a particular provision of law. It will generally say, I can follow it most of the time, but there might be an application. There might be an instance where requiring me to jail someone for seditious speech might be unconstitutional. And in those situations, I want Congress to know now that I'm going to act in a constitutional manner. And it is certainly more respectful of Congress to tell them right at the time he's signing, because that gives the opportunity to Congress, who shoves 600 provisions together in a bill, just to repass that one provision if they have a different view than the president.
I want to actually ask Mr. Edwards about that as a former member of Congress. That this was an amendment to a much larger omnibus bill, as they're called. And the president, if what you say is true, only had an option to veto the entire thing, including all of its good things, or to sign it. And what Mr. Graziano was saying is there was a middle ground. Why should the president be deprived of the access to that middle ground?
Well, there's a couple of reasons. First of all, what he describes is like a line item veto, which the courts have already said is unconstitutional. The Supreme Court's already ruled a president cannot take a piece of a bill and follow it and not follow others. He can't do that. The point is, when you send the bill back to the Congress, they can almost instantly vote on whether to override the president, or they can say, you win, Mr. President, you win. You know, that's out of there. The president can't make that decision himself. That's the problem.
Let me ask Mr. Graziano to respond to that.
Well, the president hasn't said he's not going to follow all of those provisions that Mr. Edwards is talking about in every instance. He's just saying there might be a circumstance, there might be an extreme circumstance when I am acting, for example, as commander-in-chief.
I'm curious about whether the president actually has the power through these signing statements to call for something not to be enforced. Is there a force of law that comes with a signing statement like this that the Constitution provides for that allows the president to say yes, this, and not that?
Well, first of all, as we said, the Supreme Court has already ruled that a line item veto, taking a part of a bill and striking just down a part of the bill, is not constitutional. The president doesn't have that authority.
The president is not issuing a line item veto in these provisions. The president has a responsibility to uphold the Constitution. Is it better that he secretly doesn't enforce certain provision years later? No, it's much better when he signs a law that he lets Congress know. You've been sloppy. You should not have 1,000 provisions in one bill, but you've been sloppy on these 4. The other 998 I'm fine with, but these 4 maybe.
You're saying it's advisory. He's just advising Congress to take another look at it?
No, he's saying how I may have to enforce these laws. But that isn't making a line item veto. It isn't taking them off the books. He's saying these 4 provisions that you've enacted in a very sloppy, speedy way. Yes, I warned you. You didn't listen to me. But now that I have the enforcement power, when I enforce these, 90% of the time we'll be in agreement. But there might be some instances, you could have drafted it more clear. There might be some instances when I can't follow this law and uphold the Constitution. That's not a line item veto. That's not a line item veto at all. It's upholding the Constitution.
I do agree with Todd that the president has no obligation and should not ever enforce something that's unconstitutional, which is if he thinks it's unconstitutional, he is violating his oath of office to sign it into law. If it's unconstitutional, the president took an oath of office to uphold the Constitution, and he should not make it the law of the land.
How much of this is about timing when the president objects, whether he objects in advance or he objects after the law is passed?
I think some of it is about timing, and it's rather strange to me that they would prefer the president years later to secretly not enforce or to give a secret memo to his staff. I think it's much better if he's forthright and transparent when he signs a bill. It's an opportunity for the president to signal to the executive branch and the American people that he expects certain provisions to be strictly enforced, or he's putting Congress on notice that there might be some provisions that present some special problems.
Final response, Congressman Edwards.
I don't think the founders could have dreamt that a president of the United States was going to say, this bill has been passed by Congress, which is the people's representatives. They under Article 1, Section 1, are in charge of deciding what's the law, and that it's going to be sent to the president, and he's going to sign it, and he's going to make it law, and then he's going to hold out the ability, if he chooses, not to enforce it. That is a complete violation of our entire system of government, which places the power within the people through their representatives to decide what the law is.
And we'll leave that there for now. Congressman Mickey Edwards and Todd Gattiano, thank you both very much. For more information on signing statements and the Constitution, please visit annenbergclassroom.org. I'm Gwen Eiffel.